This is TWiT.
This has been called by many people the most important digital privacy case to come before the court, maybe ever, maybe this term. It certainly builds on some other recent important digital privacy cases that the Supreme Court has had. This one involved smartphone robberies, the prosecution of smartphone robberies, and the procurement of location data about the defendant from his cellular provider. That data was obtained without a warrant. It was used to convict him, and he was sentenced to 116 and a quarter years in federal prison. So the key issue in this case is, particularly in the wake of some of the recent Supreme Court cases that we've seen on digital privacy, whether the fact that the data was being held by the third-party cellular provider meant that Carpenter had waived his privacy rights, Fourth Amendment rights, as to those bits of data, and law enforcement was just fine and dandy in obtaining it without a warrant. So that is what's at stake in the Supreme Court, and that was argued this week. And Emory, yes.
I'm sorry, Denise, that was rude. I didn't mean to interrupt.
Go right ahead.
But the other issue in the case that the ACLU raises is that, so specifically Carpenter, his cell site location data was used to convict him, but it wasn't just the day of the robbery. It was, in fact, the government pulled 117 days worth of his cell site location data from his cell phone provider, a total of something like, it was in the order of tens of thousands of individual location requests, so that it amounted to hundreds of location requests per day for nearly half a year. And so the ACLU was trying to raise the argument of whether the fact that this is historical data makes it a distinction. But yeah, the underlying issue is really all about the third-party doctrine. And so I think that we've talked about it before, but it's the third-party doctrine is the idea that you may have a reasonable expectation to certain information, but if you convey that information to a third party, sorry, Kat, get off of me. Oh, they're staying here. If you convey that information to a third party, then you lose that reasonable expectation of privacy. And that is a doctrine that goes back to a 1977 case, but that I think that most people, when you think about it in the context of today, can recognize that there's some sort of underlying problems with that, at least in the face of the reality of our connected world. It is, very difficult, maybe impossible, to not give your data to a third party. And in fact, the idea of whether we're, consensually giving that data to a third party is controversial in itself. And so,
right.
We're not going to have a decision in Carpenter until probably June. But there is some really interesting analysis just of the oral arguments and the justice's responses to the oral arguments that is sort of worth discussing. It is obviously a huge issue. At the end of the day, we are continuing to operate under the assumption that if you have any kind of third party in between you and your cell phone, that the government can just go to that third party without a warrant, just with a much lower bar as far as whether that data is. I'm sorry, guys. Cat.
It's okay. While you deal with the cat, I'll just mention a really great quote that I spotted about the case that goes to right what you're saying, Emory, which is that the third-party doctrine hinges on an interpretation of the Stored Communications Act of 1986. And in writing this up for The Hill, Adam Levin has this amazing quote about the Stored Communications Act and translating 1986 digital policy into 2017 and beyond digital policy. Remember the 80s? Needless to say, it's an old law that was written when mobile phones were the size of a Scottish terrier, and the only people who had them were drug lords, Japanese real estate moguls, and Ivan Boesky. So yes. I think he makes the point that perhaps the justices should be thinking differently about these issues and about who has your data and what your expectations are about it. than they might have been thinking in 1986. And that came through loud and clear in the oral argument, didn't it, Emory?
Yeah, so I actually haven't finished reading through the oral arguments. I've read a lot of analysis of the oral arguments, and I have begun to read through them. There's about 100 pages or so of that. I definitely recommend you checking it out. I will be finishing it this weekend. But yeah, I mean, it's, I think when you first learn about the third-party doctrine as a law student, at least if you are maybe privacy-minded like myself, it sounds incredible, and it sounds totally incompatible with the modern world. But that is the state of the law that we've been operating under so far. So frankly, when I was reading about the Carpenter case beforehand, I was very much not optimistic at all. And it sounded pretty much like under the current understanding of the law that there's no real issue here, that he gave his data to a third party. And again, whether or not the data even was his to give. So what we're talking about here is cell site location data. Is this information generated on the phone, or is it generated at the ISP about your phone? And that's really interesting in itself. As far as predictions on how this is going to go down, so far I've read that Sotomayor and Gorsuch, or Sotomayor at least certainly seems like she's on the privacy side. Gorsuch put forth a really interesting privacy argument. He suggested that he proposed the question that, if someone has their location data at Verizon and a thief breaks in to Verizon and steals that location data, or T-Mobile it was in his example, does that customer have a cause of action against the thief? And, is there some sort of conversion theory, which implies that he would be willing to extend a property interest in the data that the third parties hold, which is just really unprecedented, would be kind of revolutionary, and it would really change the landscape of how we consider our private data. And yeah, it's something to follow. It's really interesting. I went from being entirely pessimistic about this to very cautiously optimistic that we're going to get a good result in June.
Yeah, definitely. It seems like there's no breakdown on party lines on this issue. Maybe there are different approaches taken by part of the court. There's a really good piece in The Atlantic by Jeffrey Rosen analyzing the oral argument. And he writes that the conservative justices might hold with Gorsuch that Congress has created a property interest in our geolocational data, that the Fourth Amendment prevents it from invading without a warrant. The more liberal justices might hold that we have an expectation of privacy in electronic data that prohibits the government from tracking us over long periods of time, regardless of whether our property rights are invaded. Some justices might even embrace both theories. It is inspiring, he writes, in any event, to see justices as diverse as Gorsuch and Sotomayor, providing constitutional leadership about the urgent need to translate the Fourth Amendment into an electronic age. So
it's really interesting, because we've always seen in the privacy world, we've said forever that, privacy is not a partisan issue. It shouldn't be a partisan issue. And yet it frequently is. But it does feel like that landscape is shifting, that, more and more it's recognized that this is, whether you want to come down this on a property interest or individual liberty interest, this is privacy crosses the political spectrum. So it's encouraging for all those folks that are maybe early career professionals getting into the privacy law space.
Right. And I think from the technological standpoint too, it points out that the court is really putting itself in the role of trying to understand on behalf of the public what's going on here. You raised the issue: is this data on the phone? Is it at the cell site? Does that matter? My husband asked me when we were talking about the case, you mean there's no way to do anything to your cell phone so that you can't be tracked? And my understanding is that the answer to that is no. I mean, I suppose there are certain services and dark phones you can use that help enhance your privacy. But as long as you are within the cellular network connecting to a cellular tower, those towers are going to know where you are. They're going to register. There were some 13,000, as you said, Emory, instances of where they were able to pinpoint this defendant's location over time. And that's simply a function of how the cellular network works. And many people, my husband included, just, haven't put that together yet. So,
and I would think that many people, your husband included, would not consider himself as having consented to give that data over.
Right.
It's not like he's saying, yeah, you can access it. It is, you're absolutely right. There's no real way to hide that information from your provider. Another interesting point that was brought up, I can't remember which justice brought it up, but they reiterated the point that was, I think, originally expressed in Riley, that smartphones are not really optional in today's world. That you have it's not even like you have the opportunity or the option to choose between participating in the modern society and giving up your privacy, or protecting your privacy and not participating in the modern society, which is interesting and encouraging.